Good afternoon and welcome to the Society for the Rule of Law's webinar on congressional oversight. Thank you all for joining us here today. We'll get started with our program as soon as possible. Just wanted to give you a few introductory remarks. If you're not familiar with us or just stumbled upon this program, the Society for the Rule of Law is a national membership organization of conservative, center-right, and libertarian attorneys and others who prioritize the defense of the Constitution, the rule of law, and American democracy above our partisan or policy preferences. We're a membership organization. Our members make our programming possible. So if you are not already a member, please consider becoming one today. There'll be a link in the chat to our website where you can join. Membership is available at various levels, and you do not need to be an attorney. Some recent activities to give you an idea of what we do here. We do a great deal of educational programming and thought leadership like what we're about to do today, and some limited focused advocacy around rule of law and bedrock constitutional issues. Just a few highlights. Recently, some of our members joined an amicus brief making the argument that the power to reorganize federal agencies belongs with Congress, not the president. The Society for the Rule of Law Institute joined CREW, Citizens for Responsibility and Ethics in Washington, in a bipartisan letter asking for Congress to conduct oversight hearings on the president's decision to accept a luxury jet from Qatar. Our charter member, Richard Bernstein, wrote an original piece on our website praising the Supreme Court's recent decision in AARP versus Trump. I was recently in Phoenix, Arizona, where we hosted our first event outside of the Beltway, and our speaker was Clint Bullock of the Arizona Supreme Court. The video of that event and the transcript are available on our website. There'll be a link to that in the chat as well. Much else going on. I am not going to read all this, but we'll drop some more links for things you can click on and get up to date on the kind of work we're doing. Now, for our program today, we'll hear from our experts. One of them is having trouble connecting, so hopefully he will join us a bit later. But we'll hear from our experts kind of with a bipartisan overview of congressional oversight. What is that power? How does it work? Why do we have it? How can it maybe be improved if it is not working as well as it ought today? There'll be room at the back end for audience questions. You could drop your questions in the chat and I will pose them to our experts. You do not need to wait until we get to questions. As thoughts occur to you, please drop them in. This is streaming live right now, but it is also being recorded. So if you miss part of it, or if you think that a friend would enjoy it afterwards, you can share it with folks on our YouTube channel and other platforms. And that is that. Let's now turn to this panel. Congressional oversight is something I care deeply about. I'm a former congressional staffer, a Senate lawyer as well. And I said at the outset that this project of our society is to defend the Constitution and the rule of law. Well, in my view, of the three branches of government, the weakest today and the most perhaps constitutionally dysfunctional is Congress. And a lot of constitutional law problems and rule of law issues flow directly from that. So it's been important to me and important to the society to take a look at Congress in a number of programs. We've had events on impoundments, on the impeachment power, and many others, which you can also find on our YouTube channel. Today, to talk about oversight, we have Kevin Kosar from the American Enterprise Institute. Kevin is a senior fellow at AEI, where he studies Congress and American politics. He previously worked for more than a decade at the Congressional Research Service, whose work I shamelessly relied on when I was on the Hill. So I thank him for that service as well, and for continuing to explain Congress to the rest of us. We also have Suzanne Grooms, who's a partner at Cooley here in Washington, D.C. She previously served as investigative counsel to House Democrats and as a federal prosecutor. Our third panelist, should he join us, I will quickly introduce him now, is Chris Armstrong, who is a partner at Holland and Knight and a former Republican investigative counsel to both House and Senate committees. Thank you both for joining us today, and I would love to hear your wisdom. I think we're going to start with Suzanne, and she could tell us a bit about what is the oversight power. It's not explicitly mentioned in the Constitution, so what is it? What is it for? How does it work?
Great. Well, it's nice to meet everybody. I'm Suzanne Grooms, worked on House Oversight for many years. on the Democratic side. And of course, and I teach now at Georgetown Law School. I teach a congressional investigations class. So when we're thinking about congressional oversight, I think it's important to understand sort of that core of where the authority comes from. As Gregg said, it's not explicit in the Constitution, but it's been deemed by the Supreme Court to be inherent to Congress's legislative powers. So it is inherently linked to the ability to legislate, is the ability to obtain facts in order to legislate. So Congress wants to do any of its other functions that it has explicit authority to do, including the impeachment authority. It needs to get the right facts and information in order to make the right recommendations for reform and decisions. And when you think about that power, it sort of links back to really where the core of congressional oversight, in my view, should be, right? It should really be linked to facts and evidence and trying to obtain them in order to pursue some legislative agenda and some kind of reform. So the authority, the way the authority works in Congress is that it comes from the House or Senate rules and usually goes down to essentially committees. Committees conduct oversight either through investigatory committees or investigatory subcommittees. And often the chairs of those committees, especially on the House side, have subpoena authority, essentially unilateral subpoena authority on the House side to issue subpoenas to obtain documents or evidence or testimony to help support their investigative efforts. So I think that's sort of a broad overview of what the power is and how it works. Usually, Congress sends out its requests for either documents or testimony, public or private testimony. It's sort of public hearing, private testimony behind doors in a letter request first and doesn't issue subpoenas. So that's a little different than the Department of Justice, which will just send a subpoena to do an investigation. And many of them are very public. So some committees act privately and conduct investigations in private for a long time before they make them public, but often these are really done in the public sphere.
All righty. What to add to that? Suzanne has covered things so concisely and clearly. Well, she's quite right that committees are the real engine of oversight in Congress. I should mention that members, of course, can look into things, and they very frequently do look into things, even if they're not sitting on a committee of jurisdiction where they can, use committee powers, but they nonetheless will do that. I should back up and mention, as you heard, I spent over a decade at the Congressional Research Service, and so much of what I did in my day-to-day job at that agency was to support committees and legislators who were pursuing oversight, who were trying to figure things out. And oversight, we see it most often through committee hearings, but there's a whole lot of oversight that occurs outside the hearings. Just lots of fact gathering, information gathering, going over and talking to folks in the executive branch, just trying to make sense of what is going on. Because, look, Congress, despite being the first branch with all legislative powers, ultimately, to varying degrees, it is an amateur branch. You have people being elected and people who are leaving their positions, and there's this constant rotating in and out of people. And there's a lot to learn. Policy is super, super complicated, and legislators frequently are at an information disadvantage. And so oversight is a way for them, to learn up on stuff and to kind of ask basic questions like, is the executive branch following the law here? Is this private firm breaking the law or doing something that merits possibly passing a new law? So oversight kind of covers a whole range of stuff, of activities that fall outside of what we just see on C-SPAN with the hearings. And one thing I would also like to underscore, which I don't think is too often understood on Capitol Hill, or much of anywhere, is that, the Constitution declares that Article 2 that president or executive shall take care that the laws be faithfully executed. That statement essentially sets up a principal-agent relationship between Congress, the principal, and the executive branch, the agent. The executive branch is supposed to execute the law. How can Congress possibly know that it is doing that? Should it just shrug and trust that everything will work out? No, of course not. There's often confusion as to what the law means. There's often just outright defiance of following the laws. So Congress, in order to do its job, Suzanne pointed out, it's kind of inherent to the activity of being a legislature that you look at what the executive branch is up to. And if I could just put one little thing out there, which we can perhaps circle back to, the capacity to engage in oversight, I worry deeply that it's insufficient. We have approximately 180 executive branch agencies. Our federal budget's more than $6 trillion. We have really vexing administrative and policy challenges like improper payments, where people who are not supposed to get federal aid get it, or people who are supposed to get certain levels of federal aid are denied or not given enough. Huge, complicated problem. Congress's capacity to lean in on these issues and to master them and to fix them, it's not what it should be. But with that, why don't I popcorn over to Chris Armstrong?
Chris, welcome. We did give you an introduction before you were able to hop on. So, and you're muted, but we hopefully can hear you in a second. And
there we go.
Welcome.
I'm sorry to be late. As always, I moved over to my Mac and everything worked. So apologies about that. So I don't know everything that's already been said here. I'll just make a couple points and then we move into a conversation. It's important to recognize, congressional oversight investigations comes in many different types of favors, right? In terms of information request, there's a broad spectrum. There could be an information request where they're just asking how you operate, how the industry operates, how the agency operates. It's very high level. Then it moves into request for actual records, or at least answers about specific things. In terms of, if you're a company, it can be about exec pay, it can be about revenue, it can be about practices, business practices. Then you move into more, I think, difficult territory in terms of asking about actual records, right? Emails, internal memos, and that obviously applies to agencies as well. And that's where it gets a lot more contentious at times. And then that's where you have, if you're on the Hill in a chair, you have the subpoena power. But then on the, in terms of, a testimony, or at least, kind of an oral, info, there's a wide spectrum from a meeting, to a talk and ask questions, to a TI or a deposition, to a public hearing. And each of those has its own, I think, challenges. And each of those themselves can, I think, vary widely in terms of the temperature and the personality of the chair and the staff. And there's also the other axis, I guess, of, is this the type of investigation or kind of oversight that is long in time, that is more quiet, that is methodical, and that the staff actually knows what they're doing and what they're looking at? Or is it a simple, if a chair is sending 10 letters a day, odds are it's only a press release, or it's heat and it's pure bombast. And of course, the two of those, either the long term or the bombast, has its own challenges if you're the target. I'm sure this has been touched on as well. I'm sort of jumping over here. I always hated on the Hill, and I hate off the Hill as an outside counsel, the term co-equal branch, and it pained me years ago when a Speaker of the House actually used that term. The House, the Congress, if it's properly functioning, is absolutely the supreme branch, right? It's the only branch that has the power to fire members of the other branches. It's the only branch that has the power to, if it's the courts, impeach judges, abolish courts, or make new courts. Applies to the executive as well. It has more power if it wants to actually use that power, which is not always the case, than kind of any other branch. And something I think we see more and more, and this is among both parties, that Congress increasingly doesn't want to use that power because using that power has consequences. It takes hard work, it takes long work, and it's easier to be on TV often. And I guess part of that as well, and I'll close here, is it's so important to a healthy republic to have a healthy Congress, because that's where problems ought to be wrestled with and solved and fought over and debated. And that applies as well to investigations. The most powerful investigations and the most terrifying ones as outside counsel, it's terrifying is the wrong word, the more challenging ones are ones that are bipartisan, right? Because there's nowhere to hide. You can't count on the next election. This is why you saw in the 2000s, was it, let's see, Backpage.com, an investigation by PSI, it was bipartisan. It went from opening an investigation to being held in contempt in the course of, I think, about 18 months. I might be wrong about that, but at the pace of contempt, that's a short time frame. And it was a very powerful and effective investigation. And I think we should get back to more of that instead of purely, I think, partisan, and this is again both sides, investigations that in say 2 months nobody remembers. I am hopeful of a healthier Congress one day, but I guess we'll talk more about that. I'll pause there. Excited to be with you all.
Great, thanks, Chris. Well, I've got a bunch of questions, and some questions are coming in already. But before I start, was anything raised that one of the panelists wants to respond to before questions? I give you all questions. No. Okay. Well, first, Suzanne, so you teach about this at law school, and I assume you cover the historical use of oversight, and I think maybe from the movies Americans are familiar with, I think the mafia hearings, and maybe in a less flattering light, some of the Red Scare era hearings in the 40s and 50s. So maybe those are bookends of what popularly is conceived of as good and bad use of congressional oversight. Are there any particular stories that you like to teach about from history that are instructive or informative in a good or a bad way about how Congress can use this power?
I mean, I think I don't usually go all the way back to the beginning of history, but I do think there for many years there was very little sort of litigation over congressional authority. So for many years, until I would sort of say Fast and Furious, I don't remember what year that was, but maybe one of you guys do. Maybe like
09, 08, 09.
Oh yeah, whenever that was. So, for many years, we had some like snippets here and there where we would see a court get involved. But otherwise, Congress really mostly conducted its oversight authority through, there's the very first set of litigation that sets up its authority, says it has the authority. And then following that, a lot of the work has really been negotiations, accommodations processes. And it makes a lot of sense that that would be the case because the congressional calendar is very short and they really want to get information very quickly so that they can sort of hit, the legislative goals for that congressional calendar. And so if you're thinking about it that way, it gives a lot of incentive to a congressional committee that's acting effectively to want to narrow its requests and negotiate to get the kind of core things that it needs to move forward with its investigation while not fighting over sort of other things. I think what we've seen over sort of the last, whatever that is, decade, 15 years, has been an increasing set of litigation when those negotiations have been not working. And the litigation doesn't always come out in Congress's, favor. So, the core authority stays there, and yet Congress's sort of ability to get everything that in its negotiating position it will say that it deserves. So, congressional staff and committees believe that they don't need to recognize any privileges other than constitutional privileges, right? A core fight that we could have for a million years. They're going to say that we're lawyers now outside, so we'll say obviously the opposite. And it hasn't really gone through litigation, but I do think that if it went through litigation now, all the way through to the end, it's gone through some litigation, we would see that that's a power that it doesn't really have. Like the courts would not really give it that power. And I think to some extent, Congress gets to keep its power by not litigating some of these issues, right? So it gets to keep the positional stance that it has by choosing to make the arguments in effective ways where it can get the information that it needs without kind of going to the mat on things that don't work. But usually that works best when it has the most amount of public support behind it. So for example, if you're conducting a bipartisan investigation, as Chris was saying, and it's into something that is a national problem, waste, fraud, abuse, like something that you have kind of gathered up, anger and public anger over, or, real attention towards, and that's your focus, is bringing attention to that to make a change. That's really where the core of Congress's power is the most. And it can demand in those instances documents that it can then pressure companies or individuals or government agencies to hand over in ways that it gets more out of it than going through the process and kind of picking a partisan issue that people don't care about or just seems overtly inappropriate and then aggressively pushing it through litigation. It will ultimately end up in a place where the Congress loses some of its actual authorities, if that makes sense.
I comment on that real quick as well.
Go ahead.
It's exactly right that, often if the Congress tries to rely on the courts to enforce its own power, it loses more often than not, ends up with less power. And if you, put your mind in the position of the courts, you don't want to be called as the parent to, settle a dispute, among other branches. If Congress really wants records, whatever the issue is, it should use the power of the purse. It should use the nominations process. It has tools in it's a tool belt that, for I think a number of reasons, it's just really hesitant to actually use, or it doesn't have the will to use.
So speaking about the will, Chris, you talked about the power. Well, both Chris and Suzanne talked about the power about bipartisan investigations. Chris, you referenced Backpage, which was an oversight investigation of the private sector. Does Congress still have the willpower to conduct bipartisan investigations over the executive branch, or is it all shirts and skins? Kevin, you recently wrote a piece about House Republicans making moves to shut down oversight of the Trump administration. Was that in good faith because these were harassing politicized investigation attempts by the Democrats, or is it just partisanship all the way down these days? And is the Senate any different?
Yeah, sure. Well, for listeners and viewers out there, if you want to see a couple of the recent pieces I've written about Congress and oversight, pieces that actually kind of cut both ways, bad news and good news, go to understandingcongress.org. The Washington Examiner allows me to repost my columns on Congress there, and so you can see them ungated. So on the one hand, yes, we have seen, for example, the House of Representatives try to tamp down oversight by the Democrats, the minority party, by doing things like passing a rule in the House wherein a special parliamentary maneuver, which can put the executive branch on the spot to provide factual information, instead of it getting voted upon, it just doesn't get voted upon. It's an abstruse bit of parliamentary trickery, and again, you can read about it on the site I just mentioned. But yeah, it was absolutely done because the House was attempting to help Mr. Trump and his administration so that they would not be embarrassed by either having to provide information they don't want to provide or simply to answer the question. On the other hand, there is still good oversight happening. One hearing I witnessed a few months ago and wrote up involved a subcommittee of House Oversight and Government Reform. And we had Republican Texas Chairman Pete Sessions, ranking member Kwesi Mfume of Baltimore, two guys who are as unlike as you could possibly imagine. Eagle Scout guy versus a guy who got in trouble with the law as a young man. And there they were, hand in hand, holding an evidence-based, really deep dive into the issue of improper payments, which, as I mentioned before, is the government sending resources to the right people or not? Is money being wasted, ripped off, whatever? And despite, that you had younger members who showed up who decided that they were going to try to politic from the dais. One member came and had a staffer hold up a sign at one point. Mr. Mfume, Mr. Sessions, kept steering the hearing back to the facts. They had picked only people as witnesses who could provide factual-based evidence and analyses. And this was one of a series of hearings that they had done on this topic. And as the hearing closed, they promised that they were going to be drafting together legislation that they hoped the committee would report out. It was not what I expected when I got there. I thought this was going to be something that got demagogued by one side or the other, or probably both. Didn't happen. So there is good oversight occurring. I think to some degree it's about personalities, to some degree it's about interests, and some degree it's about the issue. I think Congress finds it easier to work on issues that every American is in favor of, like the federal government should not waste money accidentally or be ripped off. They find it easy to work, not easy, but they're more likely to have a chance to work together, Democrat and Republican, if the issue is low salience and very wonky, like, the Federal Register Improvement Act. Neither party can possibly campaign on that. Nobody's going to get voters riled up about it, so they can nerd out and work on those topics. Unfortunately, what that means is doing oversight on big stuff that has high salience, whether it's immigration or what have you. That's often very tough to do, certainly in the format of a hearing. Behind closed doors, probably a lot more opportunities for cooperation, but in a public setting like a hearing, real tough.
Suzanne, you mentioned kind of at the outset when you were setting the table for us, just that essentially all committees have some oversight powers or responsibilities, but there are special ones, right? There's the Permanent Subcommittee on Investigations in the Senate, there's House Oversight, or maybe first come to mind. Are they any different? I mean, how does their remit with respect to oversight differ from other committees, or how would an investigation differ from the perspective of a target if they're getting a letter from one of those committees versus another committee?
Yeah. So if you think about obviously I'm a big fan of the House Oversight Committee because that was my home for many years. But it has the broadest remit of investigatory authority. It can cover an investigation that would fall under the legislative jurisdiction of another committee, if that makes sense. So it has this very broad investigatory remit. And a pretty small, although very effective, as Kevin and I were discussing, postal and other kind of government transparency issues. It has a smaller legislative jurisdiction. Similarly, the permanent subcommittee on investigations on the Senate side, which is inside of the Homeland, yes, HISGAC. I'm trying to think of what Homeland Security and Government Affairs Committee is traditionally where like extensive investigations happen. So how is that different than other committees? As a general sense, the folks who are conducting the investigations in those places are the most experienced. They have a lot of experience. They understand how to conduct an investigation. They don't just drop the investigations. They'll stick with very extensively. So that's obviously something we always think about. And they usually have some kind of plan for their investigation that they're working through. House Oversight, usually much more public, which with its investigations. PSI, which is the Senate side equivalent, smaller, very much smaller, and has in the past done very extensive private investigations for many years before it publicly releases any information. So that's another sort of distinction between the two. But as Kevin said, any member can send a letter. It's the only distinction there is how much authority they have to take it to the next level if they're not getting a response. So it's really, a chair of the House Oversight Committee or a chair of Judiciary Committee has unilateral subpoena authority. So if they're not getting a response, they can take it to a subpoena. And a subpoena for Congress is really its most effective and most powerful moment, in my view, because the decision before taking it to a subpoena is the moment at which you have the most, the chair has the most negotiating power and the most authority on his or her own. Any time period after that, right? So you subpoena an entity and the company or the government agency does not respond. All of the powers after that, which become in the contempt space, those really require committee votes, but then really a full House vote. Senate side, it's very, very rare. House side, less rare, but still not commonly done because it takes up floor time. And there's just only so many kind of issues that people want to take all the way to sort of a full contempt vote for a variety of reasons. So really that like power and authority is at its strongest in the sort of pre-subpoena stage. But it is more often that subpoenas are used by the committees that are more aggressive investigative committees. I would add into that this sort of House Judiciary Committee now, which has has really taken on investigations aggressively in a way that it has not always traditionally. So it is also sort of taking on a large remit of investigations and issuing subpoenas. But for the most part, other committees will sort of move to subpoenas more slowly.
Chris, you talked before about Congress leveraging its other powers to support oversight, such as power of the purse. But what about these powers? So, but both subpoena and contempt. I believe there have been proposals to strengthen or clarify these powers legislatively, that the enforceability of subpoenas can be challenging with Congress.
Right.
Can you just
especially against the executive branch?
Yeah, right. So where do those things stand? Are you aware of any proposals currently to strengthen Congress's ability to issue subpoenas or enforce contempt?
I'm not aware of any that are think, likely to move. I know they popped up a couple times, over the years, but it's not an issue that enough. I think enough members are really know much about and to actually move the legislation. I wanted to touch on Suzanne's point as well. I absolutely right. The most powerful subpoena is the one that's not issued yet. Once it's issued, it's a bad press release, but there's a lot of I think room to run after that. And in terms of committees that are active in oversight, it depends almost entirely on the interest in the temperament of the chair, because there are authorizing committees who, with the right chair, are extremely powerful and do, I think, really, really good oversight. And then there's a change in chair and a person who is just not of interest, and they don't do any oversight at all. And so it's these things are, I think, very, very member specific. There's also, if you look at oversight by members themselves, Senator Warren has a in-house oversight team, and if they pick a target, they have lots of targets, lots of letters, but if they zoom in on one, they're I think very, very effective, and Warren have a pretty, I think, big microphone, which is very powerful too.
I'm going to, I can keep asking you my own questions for another hour, but we have a bunch of audience questions. So let me try to start putting some of those to you. And well, Kevin, maybe this just follows up on some of what we've already been talking about, but you mentioned limited capacity, and now we've been talking about contempt and subpoenas. Just one question was specifically directed to you. Have you thought about how we can make congressional oversight powers stronger, and what would be a reform or two that you would recommend we look at?
Sure. We kind of nosed into the conversation of the possibility of inherent contempt, which I'll leave it to my lawyer colleagues here to more clearly explain. But there's been talk about bolstering that power to really allow Congress to better kind of put the screws to a recalcitrant individual in an administration. But I have been much more of an advocate of increasing congressional capacity. And let me give you one data point.
Absolutely.
So over the last 40 years, we have seen the federal government, to the distress of conservatives like me, grow bigger and bigger and bigger, more and more programs, more and more complexity, more and more spending, et cetera, more agencies, you name it. Yet the number of House committee staff has declined over the last 40 years. And again, if committees are supposed to be the place for oversight, that trend, those conceding trends, is a problem. So I very much would like more capacity. And as part of that capacity, one of the things I have emphasized, and I've done this with my colleague Philip Wallach, is that Congress hasn't really built itself a core of people who are dedicated to following regulation. Folks on the right very much like to bemoan the administrative state and out of control regulators, et cetera. Well, one thing, Congress should probably have is people whose job is, in a nonpartisan way, to help them follow what's happening with regulations. We get, a few thousand of those moving through the regulatory process every year. There's no way currently overburdened staff, say nothing of legislators themselves, could follow it, because this stuff there's tons of it. It's super complicated, but it's utterly inherent to oversight, because regulations are an implementation of the law. So you would think Congress would have people who are dedicated to following this, but they don't. It's a huge missing piece of capacity.
Absolutely right.
And this was a question mostly, I think, directed initially at Suzanne, but others could chime in too if they want. You had mentioned that aspects of oversight can be public, aspects can be private. And the question was simply, why would committees do any of this in private? What are the thoughts that go into, from a former staffer, or how do members think about this? When would you want to conduct oversight in a private fashion?
Sure. Well, so I think a lot of oversight can be done in private if it's serious oversight and you just want information. So a congressional staffer can reach out to a company, an agency, and ask questions and get answers quickly without kind of a lot of concern and stress and process. Can get, folks to come in from an agency to give them a quick briefing on something that's happening right now. That is kind of a very effective way of moving quickly to get the core information that you want without the extensive process and transcribed interviews and a whole set of like document review.
Right.
And production is expensive and it takes a huge amount of time. So if somebody can just come in and answer your questions and give you the two core pieces of information you needed, that is a much more sort of effective way of conducting things in private. And then, the PSI private investigations were done, many of them over, one major one was done over the sort of bank secrecy issues. And they subpoenaed a number of banks secretly and obtained a lot of information secretly. And that was, of course, effective for them because people didn't even know that they were investigating it. So they couldn't sue the banks to stop the banks from producing the information. Banks were just producing information and nobody knew that it was happening. So that secrecy involved in that investigation actually allowed them to conduct the investigation without any interruption to it. But those investigations are really done less for a press release or maybe for a press release, but at the end, and more to really gather facts in private. And then I just wanted to add one thing to what Kevin was talking about, just to say, I think the most effective way to increase capacity has always been our system of inspectors general. So every agency has an inspector general. The inspector generals have large remits and large staff, some of them, and they're able to do both audits and investigations. And they have the sort of expertise for each of the agencies and an independence that allows them to do really in-depth, effective oversight within each agency. And so I think, keeping that strong is also sort of fundamental to having an effective oversight system. Obviously, congressional investigations, congressional oversight, important. But also the kind of effective IG system really massively increases the capacity of Congress. And then Congress can always ask the IGs, to take a look at something and get back sort of a deeply researched project. Same thing with GAO, right?
One thing to add to that as well, and I agree with all of that, is a lot of congressional investigations begin without the staff or the chair actually knowing if there's a there. If you suspect an industry is being, overly aggressive with a tax credit in a way that like Congress, didn't intend, you can do an investigation, but you don't know the outcome yet. So if you just launch every investigation publicly, it's easy to have a long list of investigations that have no ending. Then it looks like you're just launching investigations, every day. If it's quiet, and then if you find an issue at that, that's when you make it public, instead of attacking everybody publicly without actually knowing if they're doing anything wrong.
This is maybe really a question for all of you, but what I suppose, especially for our two former staffers or committee staffers, Chris, I think I'm reasonably sure you served in the minority on the Hill, and Suzanne, were you ever on minority staff? Okay, so a couple of questions just along the lines of whatever can the minority do with respect to oversight? I mean, if the majority is resistant, as in Kevin talked about what's happened in the House last month, if the majority is resistant to conducting oversight, what can the minority do short of winning back the majority to meaningfully conduct oversight of the executive branch?
I can start on that. So I worked in the minority once, but luckily it was for Senator Grassley. So he was able to hold up nominations, and he was kind of, on oversight, people didn't really want to mess with him or say no. And so he had much more leeway than I think one normally would in the minority.
Yes, senators generally have more prerogatives. I mean, I recall when I was during the Bush administration, I was in the Senate and we were in the majority, and I was working on nominations, but Senator Levin in the minority would frequently hold up nominations as a way to force compliance with his oversight requests. Congress, individual members of the House have fewer points of leverage over the administration. But Suzanne, any thoughts on what the House minority can do?
Sure. Well, I was in the House minority for what felt like forever. And it is always better to be in the majority. So, in the minority, your main tools are the press, public press, public opinion. And that is the thing that most creates kind of pressure for the majority to take action. So sometimes what we would, and of course, you always have kind of equal amount of time, per member and in a hearing to sort of ask questions and make your points. And, sometimes there is an ability to negotiate with the majority to get concessions, especially if there's a legislative committee, right? Like a legislative committee that is trying to reach agreement on a lot of issues often has more ability to reach agreement on its investigatory investigations, because there's sort of more chits to trade back and forth, right? And there's more of a cooperative working relationship. But we certainly in the minority worked to do as many kind of bipartisan things as we could, and to sign on to as many kind of the chairman's, especially if you think of Chaffetz. I think we kept a count. I can't remember what the count was, but we kept this huge count of every bipartisan action we took with him, and made a real point to try to do bipartisan work with him in order to sort of ask, so that when we asked him, can we do, this other additional thing, we could get a little piece of it. And I do think that I do want to make a pitch for the majority to actually investigate its own president, right? Its own administration. That doesn't have to be an aggressive dislike. Right. It doesn't mean because you're conducting an investigation or you're working on oversight, you're doing it in a way to tear down or destroy, right? It can be done, and it should be done in order to make the entity better, right? To make the agency work better, which is actually in everybody's best interest, right? So, for example, when Congressman Cummings, worked very closely with Chaffetz on Secret Service investigations when the Secret Service was having some real serious failures. That was not an aggressive attack against President Obama, and I don't think anyone would have seen it that way. It was effective oversight that was bipartisan oversight. Both members disagreed in many instances about what the solution should be at the end, right? But they could work together on developing the facts and recognizing that there was a real problem that needed to be addressed. And that is not, I don't think anything in the way that Cummings did that made people think that he was trying to attack or make Obama's life more difficult, right? And so, there is a lot of room for the majority party to investigate the majority administration when it needs to, when there are moments where it pushes outside of a line that can check and help improve the administration, the executive branch, in ways that are actually effective and helpful for their president. And I think that if they don't do that, they're just missing out on ways to make sort of this whole process work better.
Someone in the comments had mentioned the Truman Committee in World War II, which was then Senator Truman leading an investigation of government contracting, and it was seen as something that kind of strengthened our response to World War II, not as a subversive attack on the FDR administration, but cleaning up government contracting. This is sort of an interesting question. I don't know who's best to put it to, but we talked about how oversight kind of is a implied power, a corollary to the legislative power. maybe to the impeachment power, and maybe to the power of the purse and some others. In categories, when we're talking about executive branch oversight, in categories where the executive branch does in fact have wide discretion, such as maybe in foreign affairs, does oversight function differently, either in theory or in practice? Can Congress? You got a thought on that, Kevin?
Well, yeah, I can share that. It's been my experience that there are some really abstruse issues where the executive branch just has so much more experience on the topic that congressional oversight gets carried out just for educational purposes. So, last year, for example, I watched a Senate committee asking, the topic of the hearing was, I believe, relations with Southeast Asian nations. How complicated is that? So many different countries, so many different issues, different languages, cultures, leadership, political systems, all of that. And the membership were sitting there just asking people from the State Department and these outside witnesses informational questions. There was no gotcha. There was no, we think you're doing wrong. It was, we're just schooling ourselves up on this topic. And so I think that sort of thing does happen. And obviously, at certain points in time, some of these members are going to get so interested in these topics, whether it's State Department or other things that the executive is kind of dominant in, that they, may become somebody that demands questions and pushes back and requires and exercises a bit of that legislative authority.
Yeah, all I would add to that is it takes members who really specialize in an area as their top issue. So I'm thinking of kind of Intel and thinking of like Chairman Warner, Chairman Burr, and members who focus on that, and over time, build up real expertise and are able to do real oversight in a way I think has a big impact. It's not easy to do, and it takes a lot of time, though.
We're talking largely about oversight of the executive branch, but are there? We did mention some of the oversight of private industry. Are there any different ways you think categorically about those types of oversight of the executive branch versus oversight of industry that may be regulated? Or
I think it's a much different animal in terms of the powers they have or they don't have, in terms of the fear of I think reputational damage. Their priorities and their incentives are just, I think, dramatically different, and that's why if a Congress is hesitant to attack or investigate a administration, there are a large number of a private sector or tax entities that have a lot of, I think, related information. But if you're on the outside, how you look at a letter off the Hill is, I would think, extremely different than the way an agency might look at it.
From a pure legal standpoint, if you sort of take it to the sort of full extreme, if the president issues an order that something is privileged, right? Claims executive privilege over a piece of information that the agency holds. The Department of Justice traditionally has refused, due to an OLC opinion, to move forward with criminal contempt. And so that sort of takes off the table the concept of criminal contempt, which obviously there's no similar place for a private entity to go to. So the threat of criminal contempt, which, in some moments people feel like is very high or very low, has traditionally not existed in a time period where the executive branch is run by the same, the president controls the executive branch, right? So there's not going to be criminal contempt taken of an executive agency for not complying with Congress. That is why the sort of movement became, over many years, lawsuits, right? It's because what we call civil contempt, which is it's not really a term, but it's the process of Congress to exercise its contempt powers by going to court to ask for a declaratory judgment from the court. So asking the court to declare that the subpoena is a valid subpoena, that somebody is not complying with that subpoena, and that they have to comply with the subpoena, at which point there would then be a court order requiring them to comply. And then if you don't comply, the court would use its enforcement mechanisms to force the compliance. And so that has become a direction that legally entities have gone to when there's not executive branch compliance, which is just not something that happens on the private sector side. Although we can obviously talk about inherent contempt if people want to do that.
Yeah, no, but that's all useful. I mean, we kind of touched on it a few times from different angles, but yeah, that is an important point, that the contempt kind of power, punishment, the stick isn't self-executing. Congress has to, generally has to depend on the executive branch or the courts, though inherent contempt is a fun thing to talk about. But we are towards the end of the hour, so if I could just, first, thank you all, but is there one thought anybody would like to leave us with, or maybe each of you can just take half a minute? Is there one thing you think the audience should leave knowing about oversight or remembering from our discussion today?
I think more than we all, I'll just kind of in here, we all think about, I think this was mentioned earlier too, oversight as the big hearings that are on, snippets on YouTube or on TV, but there are, I think dozens of letters launched every day or at least every week. And the vast majority of congressional oversight is resolved, not in a TV moment, but through, a quiet negotiation. I think that part of it is I think largely working still.
I think Congress does some of its best work when the cameras are off.
I couldn't agree more.
Anything from Suzanne or Kevin, or have you spoken your piece?
I just wanted to add one thing to what we were just talking about and dealing with the private sector. It's been my observation that oversight can be extraordinarily powerful because it can just hit a private firm right in the wallet. Not only does the firm have to provide resources, hire lawyers to defend itself, but that firm probably has investors. It may have shareholders. And if there is press showing things that were done that were unconscionable, I mean, I think back to the pharmaceutical hearings, the pricing that we had, some years ago, where one of the executives, Martin Shkreli, was brought before Congress, and oh my goodness, it was such a bad moment for him and his company, and it had, bam, a real effect. So oversight can be a powerful thing if it's used for good.
Yeah, I totally agree. A congressional investigation can be extremely high risk, high stakes for a private entity. And I think it's always important to understand that that Congress is not a monolith, right? These investigations are done by lots of different entities and different people with lots of different rules, practices, ways that they do things. And that's the sort of space that Chris and I work in a lot. It's advising companies and individuals on how to navigate these spaces, because a lot of these issues can be dealt with through sort of negotiation and de-escalation. And then sometimes they can't, and you need a lawyer to help you through that also. Anyway.
That's a great place to end. Thank you all for taking your time today. I thought it was a really interesting conversation. I'm sure our viewers did too. Suzanne Grooms is a partner at Cooley. Christopher Armstrong is a partner at Holland and Knight. And Kevin Kosar is a scholar at the American Enterprise Institute. He writes frequently on Congress, and soon, I understand, we'll have some work out on the Librarian of Congress and the powers of the legislative branch against the executive. Really look forward to reading that. I'm sure we'll be talking about that and related issues here in our programming in the coming months as well. So to keep up on our programming, please follow us on YouTube, Twitter, Blue Sky, and LinkedIn. And please do consider becoming a member and telling your friends and family to do so as well at the societyfortheruleoflaw.org. Thank you all very much. Have a wonderful afternoon and appreciate your time today.